Welcome everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and today is the first day of the February 2026 boot camp, and we're starting with the fundamentals, which is the NCBE sample quiz. They give a sample quiz on their website, and we've added it to our Q bank with explanations, so it's especially helpful. If you just do it on the website, they don't have explanations, so we wanted to add a helpful touch. All right, so at trial, the father presented the above facts and asked the judge to instruct the jury on self-defense. A father lived with his son who was an alcoholic. When drunk, the son often became violent and physically abused his father. As a result, the father always lived in fear. One night, the father heard his son on the front stoop making loud, obscene remarks. The father was certain that his son was drunk and was terrified that he would be physically beaten again. In his fear, he bolted the front door and took out a revolver. When the son discovered that the door was bolted, he kicked it down. As the son burst through the front door, his father shot him 4 times in the chest, killing him. In fact, the son was not under the influence of alcohol or any drug and did not intend to harm his father. At trial, the father presented the above facts and asked the judge to instruct the jury on self-defense. How should the judge instruct the jury with respect to self-defense? Tough question that hinges on what's being asked, right? And that's something that's important to learn. It's not always like, do you know the law? It's like, do you know what's being asked and what's the answer to the question? They said, should the judge instruct the jury with respect to self-defense? They didn't say, should the jury rule for self-defense, right? It was about an instruction. It wasn't about a ruling. So for an instruction, all we need is evidence sufficient to raise the defense, right? Then we'll give it to the jury. If it, was it sufficient to raise the defense of self-defense? I mean, yeah, he always lived in fear. He was certain that his son was drunk. It turned out it wasn't, he right. It was a reasonable mistake. I mean, maybe not. Let's let the jury decide. But at least there's sufficient evidence, and that's the standard to instruct the jury on self-defense. So give the defense instruction because it expresses the defense's theory of the case. That's not why we give instructions, right? We give instructions if there's sufficient evidence to raise them, defenses. So deny the self-defense instruction because the father was not in imminent danger from his son. Deny the self-defense instruction because the father used excessive force. These answers might be the ultimate conclusion that the jury decides, but the question was asking about should the instruction be given. So I think B is the best answer here. And we do, explanations, key takeaways. A self-defense instruction must be given when there's sufficient evidence to support a reasonable belief that force was necessary, even if the belief later proves mistaken, right? Any questions on that one? Sorry, I didn't mean to click so fast. If you have a question, just stop me. But I think that one is a tough question, but it makes sense, right? It wasn't about should they be convicted or acquitted because of self. It was not that. It was should the instruction be given to the jury? We just need sufficiency of the evidence. Okay. Is the resident's testimony admissible? A man sued a railroad for personal injuries suffered when his car was struck by a train at an unguarded crossing. A major issue is where the train sounded its whistle before arriving at the crossing. The railroad has offered testimony of a resident who has lived near the crossing for 15 years. Although she was not present on the occasion in question, she will testify that whenever she is home, the train always sounds its whistle before arriving at the crossing. This sounds like it's going to be routine, right? Like it always sounds its whistle. It's like some mechanical thing that just happens. There's no reason to believe that it's not valid. She's not testifying that it rang on this occasion. She's testifying that it always does sound its whistle, right? So she has enough knowledge to be a lay witness to this effect of routine, right? So no, because the resident's lack of personal knowledge regarding incidents in question. No, due to the resident's lack of personal knowledge regarding incidents in question. No, because habit evidence is limited to the conduct of persons, not businesses. Yes, as evidence of a routine practice. And yes, a summary of her present sense impressions. I mean, the best answer here is that this is a routine practice. I think a lot of y'all probably got this right. Testimony regarding a business's standard operating procedure is admissible to show it likely followed the same practice during the event in question, even if the witness did not observe the particular incident, right? They're just saying that, this is the routine that typically happens. Which of the following statements about the law is most accurate as a matter of constitutional law? To keep its public school expenditures under control in a time of increasing costs, a state passed a law providing that children who have not lived in the state for at least 1 year cannot attend public schools in the state. So which is the most accurate description? So what's it discriminating against here? It's a state passed a law that children who have not lived in the state for at least 1 year cannot attend public schools in the state. So the problem with this is that it's discriminating based on their residency, their right to travel. So this could be a privileges or immunities uh, situation. Privileges or immunities is not the most common version of the concept. You usually use privileges and immunities from Article 4. This is a rare time where you'll use privileges or immunities from the 14th Amendment because it's specifically discriminating against your right to travel as a residency requirement. So here, the best answer is state racial residency requirements established for this kind of publicly funded service solely for the purpose of reducing state expenditures violate the privileges or immunities clause of the 14th Amendment. Let's look at the other answer choices. The 1 year residence requirement is valid because it does not affect any fundamental right or suspect class. State durational residence requirements that are established for publicly funded services are constitutional because they relate to government operations reserved exclusively to the states by the 10th Amendment. Because publicly funded education is a fundamental constitutional right, a state may not deny it to any class of persons who reside in that state. People who picked this answer got tricked. You do not have a right to a publicly funded education. You have a fundamental right to direct the education of your child, meaning like I could let my child go to public school, private school, homeschool, right? Like you don't have a right to a publicly funded education. What if you live in like the middle of nowhere in Nowheresville? They gotta, maybe they don't have to, right? But you do have the right to direct the education of your child. So publicly funded education is not a fundamental right. This is going to be a state durational residency requirement that's been held to violate the privileges or immunities clause of the 14th Amendment, which is, discriminating against out-of-staters. And remember what I said, privileges or immunities from the 14th Amendment is slightly distinguishable from privileges and immunities under Article 4, which is a more common answer on the MBE from my experience. So states cannot impose durational residency requirements on access to essential public services like public education when the only justification is cost saving. Such laws violate the privileges or immunities clause by penalizing new residents and burdening the right to travel. Typically, privileges or immunities is about discriminating against out-of-state residents, burdening the right to travel, and this type of durational residency requirement under the totality of the circumstances would burden that right. Tough question, this one. I think a tricky question. So the neighbor was attacked by one of the dogs and was severely injured. In the suit against the man, is a neighbor likely to prevail? A man has 4 German Shepherd dogs that he has trained for guard duty and that he holds for breeding purposes. The man has beware of dog signs clearly posted around a fenced-in yard where he keeps the dogs. The man's next-door neighbor frequently walks past the man's house and knows about the dog's ferocity. One summer day, the neighbor entered the man's fenced-in yard to retrieve a snow shovel that the man had borrowed during the past winter. The neighbor was attacked by one of the dogs and was severely injured. In a suit against the man, is the neighbor likely to prevail? No, because the neighbor knew that the man had dangerous dogs in the yard. No, because the neighbor was trespassing when he entered the man's property. Yes, because the man was an invitee for the purposes of retrieving the shovel. Or yes, because the man was engaged in abnormally dangerous activity. So here, I mean, a lot of y'all picked B. He was trespassing. But you got to remember, just because someone trespasses doesn't mean you have the right to cause them serious injury. Like you can't just have, what if they're a Jehovah's Witness and they come on your property to spread the gospel? Or what if it's a girl trying to, sell you Girl Scout cookies, right? Like just because you trespass is enough justification for, dog attacks. But if they knew of the ferocity and you had the beware of dog signs, then they assume the risk of this. So the knowledge that the dangerous dogs were in the yard leads to an assumption of risk answer. Right. In strict liability cases involving known dangerous animals, a plaintiff who knowingly and unreasonably enters into harm's way, aware of the risk, may be barred from recovery based on assumption of risk. Right. That's another point too, that this was a dangerous animal, so it's a strict liability, and usually assumption of risk is a strong answer to a strict liability claim. Like if it's like Tommy is a bomb inspector and inspects the bomb on the property and the bomb blows up. It's like, yeah, you're a bomb inspector. That's one of the risks of your job. So even though it's inherently dangerous activity, you assume the risk of that, and that would be a valid defense. So you can look for assumption of risk as a potential defense to strict liability claims like this dangerous animal situation. So a woman from,
Andrew, I actually had a question about that one.
yeah, go ahead.
Um, could you expand a little bit on when a domesticated animal falls into that strict liability? Because that's what tripped me up on that. Because I immediately think like the broad rule of just like wild animals, and the dog wasn't a wild animal.
Yeah, but the dog had dangerous propensities. Like the dog was vicious. So and it was a guard dog. I think those are factors that would lead it to a strict liability claim versus like um, a little golden doodle who has never snapped before. It's like if you knowingly um, own a dangerous animal, then it'll give rise to a strict liability claim. It's like in Florida, they have, abolished the one bite rule. Like if your dog bites someone, and this is a Florida concept, but if your dog bites someone in Florida, you're strictly liable because they've abolished the one bite rule. In some jurisdictions, they're like, you're not going to be strictly liable if your dog's never bitten anyone. But these dogs were guard dogs. They were known ferocious dogs. So that would impose strict liability just because of the nature of the animal.
Okay, cool. That makes sense. Thanks.
Yeah. So a woman from state A filed action against a retailer in state court in state B. The complaint alleged that the retailer had not delivered $100,000 worth of goods for which the woman had paid. 20 days after being served, the retailer, which is incorporated in state C and has its principal place of business in state B, filed a notice of removal in federal district court in state B. All right, so removal questions, people don't like Civ Pro. I don't necessarily like it either, but again, I was saying this before the recording. I like mathematics. I like knowing the answer is the answer. So these ones you could kind of turn into equations, like put a little V, people on the left, people on the right, kind of look it out, see if it adds up. So here we have A versus B, okay? And it's a state claim, right? So it's not like a federal question. It's not going to have, you know, there won't be a federal question that allows for removal, right? So it's not going to be a federal question. It's got to be diversity. All right, we have A versus B, and we have over $75,000, $100,000. All right, cool. We can remove, right? No problem. Be careful with removal. There's definitely exceptions when you can't remove. One of them that they trick me on sometimes. This is like to this day, if I'm going to get a question wrong, it's usually on something like this, where it's like, oh, they got me, where the plaintiff tries to remove. Remember, the plaintiff cannot remove. Removal is a device of the defendant. The plaintiff is the one who picked the court. What are you removing for? You should have filed in that court in the first place. But sometimes they'll give you a long fact pattern and they'll switch Tommy to Susie at the way in and be like, Susie files for removal. And you're like, yeah, of course. And it's like, Susie was the plaintiff. Gotcha. That happens to me. Another one that is more common is this one, the forum state defendant rule, where a defendant sitting in diversity, so in a diversity case like we have here, a defendant cannot move upward in their own state, their forum state. They're already getting the benefit of their state laws. So there's no reason for removal because removal was, a bias thing when the states had very different jury panels, let's say. So there's no risk of that. So think about that. If it's A versus B in state B court, B cannot remove because B's already in state B court. So what's the point of him moving upward in his home state? So the answer is going to be no under the forum state defendant rule because the retailer is a citizen of state B, right? There's no forum state removal for diversity cases. If this was a federal question, that's different, right? It's a federal question. But here's a diversity case, which would implicate the forum defendant rule. Anyone have any questions about that? A defendant cannot remove a case to federal court on the basis of diversity if it is a citizen of the state where the action was filed, even if all their diversity requirements are met. This is the forum defendant rule. All right, you got a little whole story here. So a man owned a house. Okay, this is a whole story that comes down to one line, and that happens on the MBE. A man owned a house where he lived with his family. The man was convicted of selling large quantities of illegal drugs, of an illegal drug from his house. Acting under state law authorizing the destruction of buildings that are used for illegal activity, the city destroyed the man's house. The man's family then rented an apartment and demanded that the city pay the rent for that temporary residence. The family relied on state law providing that any person who was dispossessed of his or her place of residence because of the actions of city officials was entitled to replacement housing at the city's expense until permanent substitute housing could be found. When the city refused to pay the rent for the apartment, the man's family sued the city in a state trial court, claiming a right to such payment under both the state law and the due process clause of the 14th Amendment to the U.S. Constitution. So he's suing under both laws. The highest state court ruled for the family, and this is a state court. Although the court decided that the family had no right to payment under state law, it held that the 14th Amendment entitled the family to payment for the rent for the temporary apartment. So, okay, No right under state law, but there is a right on the 14th Amendment or federal law. This is going to be a independent adequate question. In its opinion, the highest state court indicated that in several decisions it found cities liable for compensation in similar situations on the basis of the due process clause of the state constitution. But the highest state court declined to base its holding on the state constitution because the issue had not been properly raised in the case. Okay, so interesting. They declined to base their holding on the state constitution. Instead, they held that the ruling was under the 14th Amendment of the federal constitution, right? So here it's not based on state law. Even though it could have been based on state law, their holding was not based on state law. Their holding was based on federal law, on the federal constitution. So the city then filed a petition for writ of certiorari in the United States Supreme Court. Does the court have jurisdiction to review the merits of the case? So it wouldn't be if it was independent and adequate, if it was determined on independent, adequate state law, but it wasn't. The holding was not based on the state constitution. It was literally based on the 14th Amendment. So A is a good answer. This highest state court based its decision wholly on federal grounds. That's true. Yes, because the federal and state law issues in this case are so intertwined that a resolution of the federal law issues is necessary to facilitate a proper determination of state law issues. I don't think it's an intertwinement issue. It's a separate issue. They just wholly based it on the federal law. No, because the decision of the highest state court renders the case moot. No, because the independent state law grounds could have been used to justify the result in this case. They could have, but they weren't, right? If I had wheels, I'd be a wagon, but I'm not, right? This is what they ruled, what they held based on. The ruling was based on federal law, so that would merit federal judicial review because that's those are the facts of the case, right? So when a state court decision rests clearly on federal law, the U.S. Supreme Court has jurisdiction to review it. Even the state court could have relied on independent state grounds, but chose not to. Now, this is not the original jurisdiction of the Supreme Court. This is appellate jurisdiction of the Supreme Court. This is a writ of certiorari review, but they could, they have discretion to review it because it is wholly federal. If it was based on independent, adequate state law, they would have no jurisdiction for review. Does anyone have any questions about that one? Okay.
Yeah, why would a court choose? Oh, go for it. Go for it.
No,
My
no,
bad.
good. No, no, good.
Oh, why would a court choose to just use federal law and not state? Is that like a benefit to their
I
case?
mean, it's hard to speculate, but like, it's really hard to speculate, honestly.
Yeah, that's
Like,
just like a question then.
yeah, it's just like I hear you, it's just like a bar exam question, but I mean, not to say that there aren't scenarios. Like maybe they wanted to leave an avenue of review to the federal court, and that was like the best way. Or maybe, the state cases were contradictory to each other. They did say there, at the beginning there was something about the state constitution that said this, but that case that said that. Maybe they're just like it just makes more sense to only base this on federal law. Let's just defer to the federal law. Again, it's difficult to speculate, but they do some shit on the MBE that would never happen in the real world. Like for some reason, whenever someone buys a piece of property, they just don't record it. Like when in the history of buying property or on the MBE, everyone has adverse possession. Like people just don't know that someone is squatting on their property. Like things happen on the MBE that would never happen in the real world. That's probably why they're getting rid of the MBE, right? We're gonna be leaders for sure in the next gen bar, for better or for worse. But yeah, the MBE is on its way out, and that's because of feedback from test takers that it's a little bit too focused on memorization and too focused on laws that are not necessarily modern. Okay, is the sporting goods shop legally entitled to reject the posters? A sporting goods shop contracted with the publisher to buy for sale in a store 1,200 posters featuring a professional golfer. During production, the image of the golfer was inadvertently reversed, and the right-handed golfer appeared to be left-handed. When the posters were delivered on the date provided in the contract, the sporting goods shop noticed the discrepancy, which had no provable significant impact on the effectiveness of the poster. In the opinion of the shop management, however, the posters did not look as good as they had in the catalog from which the shop had ordered them. So here we're going to orient ourselves in a contracts question. Well, it's UCC, right? Because it's for the sale of goods. Okay. Is it a statute of frauds thing? Not really, because they don't really tell us if it's in writing or not, and they don't tell us how much it is. So I don't think it's getting to statute of frauds. Okay, so it's probably just a UCC contract where now we're past formation, we're at execution. And here it was right-handed, but they were supposed to be left-handed, right? So UCC has the perfect tender rule. That doesn't sound like a perfect tender. It had no provable significant impact, but still, that's not what he ordered. It's not a perfect tender. If this was uh common law and it was like Bad Bunny was supposed to do this, but he, didn't do exactly that, it's like he still performed, right? He's still going to get paid. But in the UCC, you have perfect tender, not substantial performance. It doesn't matter if it has a provable significant impact or not. You ordered it. You wanted right-handed and you got left-handed. So I think you're going to be able to refuse to accept this, right? So is he legally entitled to reject? No, because the nonconformity does not materially alter the value of the posters to the sporting goods shop. Remember, it's perfect tender. No, because the publisher must be given an opportunity to cure the nonconformity before the sporting goods shop can reject the posters. That's probably implying an installment contract. Installment contracts, you have an opportunity to cure, where delivery occurs sequentially in batches, week after week, month after month. But that's not what happened here. This is a one-time poster delivery. Yes, because the posters did not conform to the contract. I like that. Yes, because the publisher has breached an implied warranty of fitness for a particular purpose. No, there was no particular reason that it was represented to work for. It was just posters. So under the UCC's perfect tender rule, a buyer may reject goods if they fail in any respect to conform to the contract, even if the defect is minor or aesthetic. Okay, so a woman borrowed $800,000 from a bank and gave the bank a note for that amount secured by a mortgage on her farm. Several years later, at a time when the woman still owed the bank $750,000 on the mortgage loan, she sold the farm to a woman for $900,000. The man paid the woman $150,000 in cash and specifically assumed the mortgage note. The bank received notice of this transaction and elected not to exercise the optional due on sale clause in the mortgage. Without informing the man, the bank later released the woman from any further personal liability on the note. After he had owned the farm for a number of years, the man defaulted on the loan. The bank properly accelerated the loan, and the farm was eventually sold as a foreclosure sale for $500,000. Because there was still $600,000 owing on the note, the bank sued the man for the $100,000 deficiency. Is the man liable to the bank for the deficiency? So how did the man take this? The man paid the woman and specifically assumed the mortgage note. So he's primarily liable because he expressly assumed it. So, yes. No, because the woman still have been primarily liable for payment, but the bank had released her from personal liability. No, he's personally liable. He expressly assumed it. No, because the bank's release of the woman from personal liability also released the man. No, he's expressly assumed it. Yes, because the bank's release of the woman constitute a clogging of the equity of redemption. I mean, that's just not what's going on here. I don't even really, I'm not gonna say I don't know what that means, but like that's just not what's going on here. Something that would clog the equity of redemption would be like some form of like deed in lieu of foreclosure that doesn't allow a person to, oh no, it would be this. It would be a clause that says there's no such thing as the equitable right of redemption, right? Like there's an equitable right of redemption and statutory right of redemption. Statutory right of redemption, you don't automatically get. You do get an equitable right of redemption, and agreeing ahead of time with the party to waive an equitable right of redemption would constitute a clogging of the equity redemption. So I don't want to say I don't know what that answer means, but it's just not the answer to this question. What the answer to this question would be, yeah, the man was personally liable, and the release of the woman had nothing to do with him because he specifically assumed the mortgage note. So expressly assume personal liability. When a buyer assumes a mortgage, they become personally liable for the debt. A lender's later release of the original borrower does not impact the assuming buyer's liability for any deficiency after foreclosure. Remember, that's expressly assuming. If you take subject to a mortgage, then you become secondarily liable. You're the surety, where the original party remains personally liable for the deficiency. And again, you feel free to stop me anytime if anyone has any questions. Of what crime, if any, can the friend probably be convicted? A young man suggested to his friend that they steal a large screen TV from a neighbor's house. The friend was angry with the young man and decided to use the opportunity to get even with him by having him arrested. The friend said he would help, and that night he drove the young man to the neighbor's house. The young man broke in while the friend remained outside. The friend called the police on his cell phone and then drove away. Police officers arrived at the scene just as the young man was carrying the TV out the door, at the back door. So what did the friend do wrong? The friend said he would help, but he called the police and set him up. No, you are a I don't want to say a horrible friend, but like you're definitely working for the police here. You're on the side of justice and not on the side of, you know, robbing the house. You are not a criminal here. You're a, I guess, a good Samaritan, right? Like, I mean, yeah, I guess. It's not how I would have thwarted the crime. I would just talk them out of it. I wouldn't have like said I would go along and then called the cops up. That's not how I operate, but you're still not a criminal here. You're a uh worker of the police, right?
I
So
got a question on that, Andy.
yeah.
So, sort of like a confidential informant, what happens in that same scenario? I'm just talking, and he goes in there and he shoots somebody in there, right? You're saying he couldn't get charged with no crime, even if he called the cops before something happened before? Because he set it up. He's basically a conspirator. That's what I was thinking.
Well, the reason that I mean, okay, the friend, no, the young man,
He didn't call
uh,
the cops till after he got there. I mean, I get, if he would have called them right before they even left.
yeah, I mean, I could see an argument there. I mean, the counter argument would be he never had the mens rea, he never had a guilty mind, and therefore he's not guilty. But there's also a reckless argument there that like you know, assume the risk of what could happen, and until it was truly thwarted, you may have been on the hook, right? I don't know. That's a good question. That's a good thought. And I don't have the question in front of me with the exact details, but yeah, it would be a little bit dicey if a killing had occurred inside and then saying that like you were, even though you weren't necessarily a conspirator to the completion of the crime, you were a conspirator to the setup of the crime, which reasonably puts someone in danger. I mean, again, I don't know. That's a good question. Hopefully, they don't ask that exact question on the bar exam. But here, the takeaway is that it's no crime because he was just, you know, didn't have a guilty mind and was setting him up to get arrested. I agree. I don't love this question, but it is no crime here. And they're saying, can the friend probably be convicted of conspiracy? The answer is no, because he didn't have a guilty mind. That's the takeaway. Now, could the young man be convicted of conspiracy? What's the best answer in the law, right? What's the in law
No,
school?
right? Because you need two people for that.
Well, the best answer in law school, and that's what I'll tell anyone who goes to law school, just go to sleep whenever your teacher calls and you just say, it depends, right? It depends, right? Because conspiracy, remember, there's a bilateral requirement at common law, and then there's a unilateral requirement under the model penal code. So in the model penal code, it could definitely be argued that he could be guilty of conspiracy because it doesn't take a second guilty mind. Where at common law, no way, because there's only one guilty mind. So at common law, no conspiracy. Under the model penal code, potentially conspiracy on behalf of the young man because he was a guilty mind and there was another, and the model penal code does not require plurality of intent, right? So, anywho, no crime is the best answer to this question. A person cannot be guilty of conspiracy if they never truly agreed to commit the crime, only pretended to go along with the plan in order to sabotage it. Yeah, so it's just the best answer to that question. So, is the court likely to grant the hospital's motion? A 50-year-old nurse who had been fired from his job at the hospital told his attorney, I was fired because of my age and I want to sue the hospital. Based on this information, the attorney filed an age discrimination complaint against the hospital in federal court. As it turned out, the hospital had hired a 52-year-old man as the nurse's replacement, a fact that rendered an age discrimination claim unavailable. The hospital responded to the complaint by filing a motion for sanctions against the nurse's attorney. So this one is testing Rule 11, which they test a good amount, right? Rule 11 is the idea where you can be sanctioned as an attorney if you file a frivolous complaint or, you file a complaint that has no legal backing, right? Like as an attorney, that's Rule 11. And it's important that Rule 11 is for the pleadings, right? For like, the original, not for motions, right? It's for the pleadings. And under Rule 11, if opposing counsel moves for sanctions, they have to comply with the safe harbor provision and give you time to amend that before sanctions can be granted. Whereas if the court moves sua sponte on its own, then they can impose sanctions right away. So this was testing the safe harbor provision where you have to have some time before sanctions can be granted. So no, because sanctions are not proper against the attorney of a represented party. No, that's who they're proper against. If the person is represented, you sanction the attorney, not the person. You only sanction the person if they're pro se, representing themselves, and they can be sanctioned under Rule 11. No, because the hospital failed to give the attorney the chance to withdraw the complaint in advance of filing the motion to court. Yes, because the nurse's attorney failed to conduct a reasonable pre-filing inquiry. Yes, because the nurse's complaint contained legal contentions that were not warranted by existing law based on the facts in this case. I mean, D would be a good answer, right? C would be a decent answer, but here it's B because of the safe harbor provision. Before filing a motion for sanctions under Rule 11, the moving party must serve the motion and allow 21 days for the opposing party to withdraw or correct the challenge filing. Failure to follow the safe harbor procedure makes sanctions unavailable. That makes sense, right? The safe harbor provision, 21 days that you have to wait before you can move for sanctions. So you have to serve the motion, give them notice, and then they have the opportunity to retract and be like, oh yeah, actually we're not claiming this. That was terribly wrong of us. Whereas if the court moves on its own sua sponte, the safe harbor rule will not apply. It's a 21-day rule. Any questions about that? A daughter was appointed guardian of her elderly father following an adjudication of his mental incompetence. The father experienced periods of dementia during which he did not fully understand what he was doing. The father later contracted to purchase an automobile at a fair price from a seller who was unaware of the guardianship. At the time of the purchase, the father was lucid and fully understood the nature and purpose of the transaction. What is the legal status of the transaction? The contract is enforceable because a reasonable person in the situation, a seller, would have thought that the father had the capacity to make the contract. The contract is enforceable because it was made on fair terms and the seller had no knowledge of the father's guardianship. The contract is void because the father was under guardianship at the time it was made, or the contract is voidable at the option of the father. So typically incapacity leads to voidability, right? Like if they're a minor, they can actually enforce the contract, but not if it's adjudicated incompetence. Adjudicated incompetence means like they're never going. It's not like it's a moment of transgression. It's like they are unable to contract. So any contract that's made with a person who's been adjudicated incompetent is void, right? So a contract made by a person under a court order of guardianship is void, regardless of fairness or the other party's awareness of the guardianship. It's just a key takeaway. So who's likely to prevail? The two sisters own a single tract of land as tenants in common, each holding 1/2 interest. The younger sister entered into a 3-year written lease with a tenant. The lease described by metes and bounds a specified portion of the land, which consisted of about 40% of the total tract. The tenant went into sole possession of the lease portion of the land. The older sister has sued both the younger sister and the tenant to establish the older sister's right to possession of the lease portion of the land. Who is likely to prevail? The older sister, because the younger sister cannot unilaterally partition the land without her older sister's consent. Facts, yes. The older sister, because the younger sister may not lease her undivided interest in land without the older sister's consent. The younger sister and the tenant, because the older sister has been excluded only from the specified portion of the land subject to the lease, which makes up less than 1/2 of the land's total area. And the younger sister and the tenant, because the younger sister's lease to the tenant was necessarily for less than a fee simple interest. So here, I mean, tough question maybe, but a simple answer, right? Like, the younger sister entered into a lease, and the lease described, which consisted of about 40% of the tract. The tenant went into sole possession of the lease part of the land. The older sister has sued the younger sister and the tenant to establish the older sister's right to possession of these portion of land. Yes, as a co-tenant, doesn't matter if tenants in common, JTROS, you have an equal right to use the entire land. It's not like you get the left side, I get the right side. It's like they can't oust you. If there's a tenant, you have the right to live with the tenant on the property. So as a co-tenant here, you have a right to the entire access of the land, right? So it would be a unilateral partition to just cut you off. maybe if you petition to the court and the court granted the partition, potentially, but like you can't just draw a line in the sand. A co-tenant cannot lease exclusive possession of a physically defined portion of commonly owned property without the other co-tenant's consent, as this infringes on the other co-owner's right to possess the entire property. Like I said, it's not like one tenant has the left and one tenant has the right. They both are allowed to, you know, walk around the entire property.
Andrew, I have a question about that.
Yeah, sure.
So I did those questions on like the link that you sent and not here, but number 12 was like a completely different question.
Maybe they
Yeah,
changed it.
I've got the same thing. I got a 23-year-old woman one.
Yeah.
All right, we'll check that one out when we get to it. Is this one the same? 13?
I think that one's the same still. Yeah. It's just
Okay.
the number 12.
Interesting. I wonder why. So I'll check that question out. At the end, we'll check that question out. So, is this law constitutional? A state law prohibits any barbershop licensed by the state from displaying posters in support of any current candidate for public office or displaying or distributing any campaign literature in support of such a candidate. No other kinds of posters or literature are subject to this prohibition, nor any other types of commercial establishments in the state subject to similar prohibitions. Is the law constitutional? No, because it treats barbershops differently from other commercial establishments. No, because it imposes a restriction on the content of subject matter of speech in the absence of any evidence that such a restriction is necessary to serve a compelling interest. Yes, because it leaves political candidates free to communicate their campaign messages to voters by other means. Or yes, because the operation of a licensed barbershop is a privilege and therefore is subject to any reasonable restriction imposed by the state. So here, I mean, they're saying that no barbershop can display any public candidate. That's strict scrutiny. That's content based. It's saying, not no one is allowed to have a sign that's so bright that it blinds people as they go by, right? It's not time, place, and manner. It's, you could support your candidate. It's like no one could have had a Seattle Seahawks flag outside of their restaurant yesterday. Like you can do whatever you want. So, I mean, not whatever you want, but the government, if they're going to challenge it or they're going to impose that type of restriction, it would have to comply with strict scrutiny and have to be necessary to achieve a compelling interest, be narrowly tailored in the least restrictive means possible. So here, yeah, this is the one that has the language, the compelling interest, necessary to achieve a compelling interest. Definitely make sure you got the scrutiny levels. I had a student at the beginning ask me, like, where do I start? And I mean, there's some fundamental things you need to know code. Scrutiny levels and their definitions, definitely one of them, right? Rational basis, legitimately related to a reasonable or rational purpose. Intermediate scrutiny is substantially related to an important government interest. And then, like we said, strict scrutiny is narrowly tailored to a compelling government interest and is the least restrictive means possible. So it's law that restricts speech of subject matter, especially political speech, subject to strict scrutiny, unconstitutional unless the government proves it is narrowly tailored to achieve a compelling interest, right? And that's for content based, not content neutral, which would be a time, place, and manner, which would be a heightened intermediate scrutiny, narrowly tailored to a important government interest, substantially related, and leaves alternative means or avenues of communication. So, should the defendant's motion be granted? A defendant was prosecuted for mail fraud. At trial, the defendant moved to have all witnesses excluded from the courtroom, and the court granted the motion. The government named the investigating FBI agent as a designated representative. Okay, so this person stands in the shoes of the government and is the defendant and has a right to be there for all, important things. Upon learning that the agent would be giving testimony during the trial, the defendant moved that the agent also be excluded from the courtroom. Should the defendant's motion be granted? No, provided the government can show that the agent's presence is essential to the presentation of its case. No, because the government has a right to have its designated representative remain in the courtroom throughout the trial. I like that. Yes, because the agent's testimony might be influenced by the testimony of other witnesses. Or yes, because the defendant has a right to exclude all persons who may be called as government witnesses. So, B, right? That they have the right to remain throughout the trial just like a defendant would have, because they essentially are the defendant because they were the designated representative. Does anyone have any questions about that one? Although witnesses can normally be excluded from court under Rule 615, a government's designated representative, such as a lead investigating agent, is allowed to remain in the courtroom throughout the trial, even if they are expected to testify. Okay, at the close of evidence, both parties move for judgment as a matter of law. And again, this is another thing. Like I said, you should know con law scrutiny levels. You should know the standards for JMOL, summary judgment, new trial, right? That's very important. So JMOL, it's that no reasonable juror could find for the non-moving party, or there's substantial evidence in favor of the moving party to, take the case out of the hands of the jury. A man entered a tavern in an obviously intoxicated condition, was refused service, and was ordered to leave and escorted out. Just after leaving the tavern, the man staggered across the road toward the liquor store. As he was crossing the road, the man was struck by a car and severely injured. The man sued the tavern for his personal injuries. At trial, the evidence established the facts as set out above. At the close of evidence, both parties moved for judgment as a matter of law. How should the court rule in these motions? Deny both motions and submit the case to the jury because reasonable jurors could conclude that the accident was foreseeable. Deny both motions and submit the case to the jury because a tavern is a place of public accommodation. Grant the tavern's motion because there's no evidence that the tavern breached a duty to the man. Grant the man's motion because it's undisputed that by being ejected from the tavern, the man was put at risk. So here, they didn't do anything wrong. The man was obviously intoxicated, refused service, and they sent him to leave. Now, we don't even know if there's dram shop liability here. We're like, can you be liable for overserving? We don't even know about that. But they didn't overserve the man. They just told the man to get out. I mean, say I have a little tutoring center and some guy comes in, staggering. I'd be like, dude, get out of here. You can't have kids learning math in here, right? Same thing. Like, they're running a peaceful establishment. They're allowed to kick a man out. A bar does not have a duty to like bring in a drunk person and like sober him up, right? They just said to leave, right? And so then when he got hit, they didn't breach any duty. So I would say, yeah, there's no evidence that the tavern breached the duty to the man, right? Usually, if it's summary judgment, JMOL, not usually, but often you will send it to the jury, right? Like, I mean, you will just deny it and be like, there's evidence. They could find either way. But here, there's no evidence that they breached the duty to the man. Does anyone have any questions about this one? Yeah, this one's, I mean, they didn't breach any duty.
Andrew,
Yeah.
this is Ola.
Hello.
Can you hear me?
Yeah, I hear you loud and clear.
Yeah. Can you please explain JMOL and RJMOL? I know when you apply for them, right? But you just said something now that eluded me.
So the standard that needs to be proven, if you move for a JMOL and preserve and then later move for a renewed JMOL, it's the same standard. The standard is that no reasonable juror could find for the non-moving party, right? That like summary judgment is there's no genuine dispute of material fact. JMOL and renewed JMOL is no reasonable juror could find for the non-moving party. There's substantial evidence in favor of the moving party. And then a new trial would be that the verdict is against the weight of the evidence, or there was juror misconduct or something that would allow for a new trial. But usually the verdict is against the weight of the evidence. So associating those standards with the motions is really a good idea. So JMOL is no reasonable juror could find for the non-moving party. Summary judgment is there's no genuine dispute of material fact. And new trial is that the verdict is against the weight of the evidence. Okay, so a protester brought an action in federal court against a police officer alleging that, by the way, are these the same questions now? Have they, like, these are the same questions? All right, let me know.
Yeah, they're the same.
They must have just changed that one question. I don't know why. I mean, I feel like that question was proper, that it was a unilateral partition, but I don't know. Maybe there's something they didn't like about it. I mean, who knows? A protester brought an action in federal court against a police officer alleging that the officer's use of force in arresting the protester violated the protester's federal civil rights. During the jury trial, the eyewitnesses gave conflicting testimony on the arrest. At the close of evidence, the protester moved for JMOL, which the court denied. The court instructed the jury that the protester's burden of proof was clear and convincing evidence rather than the correct burden of preponderance of the evidence. The jury returned a verdict for the officer, and the court entered judgment accordingly. What is the protester's best option for challenging the judgment? Seek a new trial because the jury instruction affected the protester's substantial rights. Seek a new trial because the verdict was against the clear weight of the evidence. Okay. Both potential reasons for new trial. I didn't mention that. If the jury instruction affect the protesters' substantial rights, if something affected their substantial rights, that's a good reason for a new trial. Or the verdict against the clear way of the evidence. These are both correct standards. So we're gonna have to pick between them. Seek JMOL because the jury did not have legally sufficient evidence to find for the officer. Again, that's the right standard. Or seek judgment as a matter of law because the jury's findings were clearly erroneous. Well, we don't want C or D because they've already entered a verdict, right? So it would be renewed if it was, but like they already made a verdict against you. So you're gonna need a new trial here. So how are you going to get the new trial? Was the verdict against the clear weight of the evidence? Not really. It was just the burden of proof was wrong. It wasn't anything about what the verdict said compared to the evidence. It was that they gave improper instructions, and if the improper instructions affect the protester's substantial rights, then that's a good reason for a new trial, right? A jury instruction that imposes a higher burden of proof than required by law is reversible error if it affects a party's substantial rights. The proper remedy is to move for a new trial under Rule 59. So B is incorrect because it can be based on verdict against clear weight of evidence, but that's not the strongest argument here because they don't give us anything in the fact pattern to show that there was a verdict against the weight of the evidence. It was just that the jury instructions were wrong. It seemed like the verdict did kind of align with the evidence. It was clear and convincing. It just wasn't beyond the preponderance of the evidence. If the businessman asserts a claim against the television stations for broadcasting his picture as he disembarked, is he likely to prevail? An attempt was made to hijack a commercial airliner while it was in flight from San Francisco to New Orleans. Within minutes, however, the hijacker was seized and the plane proceeded to its destination. Upon the plane's arrival, television stations broadcast pictures of the passengers they disembarked. Among the passengers pictured on television was a businessman who was supposed to be in Chicago on company business. This is like that guy who went to the Coldplay concert. The disclosure that the businessman was in New Orleans and not Chicago at the time resulted in the loss of a position with the company and great humiliation and embarrassment for. I'm going to always refer to this as the Coldplay guy, right? Like, does he have a case? They put him on the Jumbotron. He was with his mistress. Like, no, bro, you were out there dancing in public. Like that, it's newsworthy. Or, a plane is getting it's having an emergency landing. Like people want to see that on the news. So you're not going to have a good cause of action here. Did everyone get this question right? Anyone have any questions about this one? The media is protected when reporting on matters of public concern, even if individuals pictured suffer personal or professional consequences as a result. Newsworthy events involving public settings are not considered invasion of privacy. All right, this is a good question. I mean, this is why the MBE is tricky little test, right? Oh, my mic is breaking a bit. Is it still? Sometimes that happens. Can you guys hear me clearly?
Yeah.
All right, let me know if it breaks. I can go up in my office, but sometimes my office is worse than down here, so I don't know. I don't know. A company contract with a builder to construct a new corporate headquarters for a fixed price of $100 million. At the time of the contract, structural steel was widely available and was included in the contract as a $6 million item. Before work began on the project, tornado damage shut down the production facility of the biggest structural steel supplier in the country, and the price of structural steel increased by 20% as a result. The builder informed the company of the steel price, and the parties then orally agreed to increase the project price to $101 million. The builder proceeded with construction and delivered the project on time. The company paid the builder $100 million, but refused to pay the additional $1 million. If the builder sues the company for $1 million, is the builder likely to prevail? No, because the modification was never reduced to a writing signed by the party to be charged. No, because there was no consideration for the modification of the contract. Yes, because the company's promise was supported by consideration. Yes, because the modification was fair and equitable in view of the unanticipated increase in the price of structural steel. So this is a tough question, right? A lot of you probably picked B here because you know the law, and that's why MBE is a tricky little test. The law is that at common law, you need consideration for modification. Under the UCC, you only need good faith. It doesn't need to be in writing. A modification can be oral. It wasn't supported by consideration. You already had the duty to deliver, right? To build this. So you're not doing anything you weren't otherwise obligated to do. The answer is going to be between B and D. B is a tempting answer because that is the rule at common law. You need modification for consideration. But what's known as the modern prevailing view, right? The modern prevailing view, what they've recently come to terms with is that a modification even without consideration, will be enforceable at common law for a common law contract if it's fair and equitable in view of the unanticipated increase or unanticipated changes. So if you see those terms, fair and equitable in view of unanticipated changes, then you don't need consideration for a modification at common law. So tough question, right? A contract modification made before full performance is due can be enforced without new consideration if it's fair and equitable in light of unforeseen circumstances that arose after the original agreement. So, yeah, the restatement, right? Like it was true that they needed traditional common law would require new consideration for modification. The restatement provides an exception for fair and equitable modifications in response to unanticipated circumstances. So, fair and equitable under circumstances, unanticipated circumstances. That's the modern prevailing view for a common law modification. How should the court rule with regard to grand jury testimony? At a defendant's trial for extortion, the prosecutor called a witness expecting her to testify that she had heard the defendant threaten a man with physical harm unless the man made payoffs to the defendant. The witness denied ever having heard the defendant make such threats, even though she had testified to that effect before the grand jury. The prosecutor now seeks to admit the witness's grand jury testimony. How should the court rule with regard to the grand jury testimony? So let's see. The prosecutor called a witness that she had heard the defendant threaten a man with physical harm unless he made payoffs. The witness denies ever having heard the defendant make such threats, even though she had testified to that effect before the grand jury. Now they want to bring the grand jury testimony. Okay, so this is a tough one. Usually we're going to bring in prior consistent statements only for impeachment, unless it was made under oath, right? And this was before a grand jury. So because it was made under oath, we can bring it in for impeachment purposes and substantively. So admit the testimony because it contains a statement by a party opponent. Admit the testimony both for impeachment and substantive use because the witness made the inconsistent statement under oath at a formal proceeding. Admit the testimony under the former testimony exception to the hearsay rule. Exclude the testimony for substantive use because it's a testimonial statement. So here, like I said, we're going to allow for both impeachment and substantive use because there's a prior inconsistent statement made under oath. If it's not made under oath, it can only come in for impeachment purposes. If it's made under oath, then it can come in substantively as well. Any questions on that?
Yeah. Is there any other reason why it can be brought on both other than made under oath?
So it's not going to come in as prior testimony because the party's not unavailable. The former testimony could come in if they're now unavailable, but they're available. So it would have to come in, for an exception that doesn't require unavailability. And here it's a prior inconsistent statement. So it can come in for impeachment, and then because it's made under oath, it could come in substantively as well. So for this one, I can really only think of one reason we're bringing it in, which is as a hearsay exemption, right? Carved out as non-hearsay as a prior inconsistent statement made under oath can come in for impeachment purposes and substantively as well. Did you go ahead?
Let me express here a minute. What is STD again? What's that acronym?
I think that's sexually transmitted disease. No, I'm
oh, Jesus.
I'm kidding. It's for a statement against interest, former testimony, and dying declaration. And I know that was like a funny moment. I think they changed it to STIs to be more scientifically accurate. But in science, on the test, that's like the mnemonic that everyone remembers. You got to remember my legs. I guess that can be an innuendo too. And then everyone remembers STD that one of my students came up with for statements against interest, former testimony, and dying declaration are three of the hearsay exceptions that require unavailability. There's also family history and records and statements made in procuring someone's availability, right? Like those are other ones that could potentially come in. But the main ones you see are statements against interest, former testimony, and dying declaration. I was just joking with you. That's what the original mnemonic stood for. So when a man refuses, buyer likely to prevail. The man later agreed to sell the home to a buyer. The sales agreement did not mention the shutters. The buyer did not inquire about them, and the buyer did not conduct a walk-through inspection of the home before the closing. The man conveyed the home to the buyer by warranty deed. After the sale closed, the buyer noticed that the shutters and brackets had been removed from the home and that the window frames had been repaired and repainted. The buyer demanded that the man return the shutters and pay the cost of reinstallation, claiming that the shutters had been conveyed to him with the sale of the home. When the man refused, the buyer sued. Is the buyer likely to prevail? So these fixture questions can be a little bit tough, right? first off, is this a trade fixture or a residential fixture? Because they're different, right? It's a home. It's a residential fixture. Okay, the rule of residential fixtures is they stay with the home unless they are you know, contracted away. If it says like, hey, when I'm leaving, I'm taking the chandelier, like, and there's a replacement downstairs that you can put in, that's fine. But if it's like just in general, um, then there's shutters, they're probably fixtures, right? I don't think he could have removed them. So no, because the sales agreement did not mention the shutters. No, because the window frames have been repaired and repainted after removal of the shutters. Yes, because the shutters became fixtures, I believe is the best answer. Yes, because the man gave the buyer a warranty deed and the absence of the shutters violated a covenant in the deed. No, it's just here. These are residential fixtures. Think of like if you shook the house, what would remain with the house? Like uh, things that are affixed to the house is the best way of thinking about it. Trade fixtures can be removed so long as the place is restored or they pay for restoration. But this is not a trade fixture. This is not a commercial fixture. This is a residential fixture that would remain affixed with the house, absent any agreement otherwise. So items that are permanently affixed and specially adapted to the property, such as custom fitted shutters, become fixtures and transfer to land unless explicitly stated in the contract. So the president of a pharmaceutical firm received a report from his testing bureau that a manufactured lot of the firm's anti-cancer prescription medication was well below strength. Concerned about being able to fulfill contractual commitments, the president instructed his staff to deliver the defective lot. A cancer patient had been maintained on the drug, died shortly after beginning to take the defective pills. Medical evidence established that the patient would have lived longer had the drug been at full strength, but would have died before long in any event. Okay, so you sold the dude defective pills. You're a monster, right? This is what got Luigi so upset, right? This kind of activity. So you're a monster, right? You sold defective pills. Now, you didn't like you didn't kill someone who wasn't gonna die, but let me posit this to y'all. Everyone's gonna die. So murder is always causing someone to die sooner than they would have all like just because he was gonna die, you made him die sooner than he was gonna die, you're guilty of murder. If you reduce anyone's life, that's murder, right? Like that I don't know if that's a tough concept for you to understand, but like it's murder, even though he was already sickly and on his way out. You killed him 4 days early, you still killed him. So here, there's definitely a strong case for murder because, knowing disregard for human life, right? Defective cancer pills. And then he instructed them to do it. And then, he would have lived longer. That's enough to justify murder. So, yes, because the distribution of defective lot was a regulatory offense. Okay, so the president was convicted of murder on appeals. On appeal, he argued that his conviction should be reversed. Should the conviction be reversed? The answer is no. The conviction should stand. No, because the intentional delivery of adulterated or mislabeled drugs gives rise to strict criminal liability. No, because a jury could have found that the president's conduct was sufficiently reckless to constitute murder. Yeah, it's not going to be strict criminal liability, right? This isn't like statutory rape or bigamy or polygamy or something like that. It's not a regulatory crime or administrative crime. It really is like a guy's mens rea. Did he recklessly disregard human life? And the answer is likely so, right? So murder can be established through conduct that is recklessly indifferent to human life, and causation can still be proven even if the victim was already seriously ill, so long as the defense actions accelerated the death. Anyone have any questions about any of the ones that we did today? Oh, Natalia, you're saying so B, yeah. So
The last one is B, right?
yeah. Sorry, I
Okay,
just
sorry, I kind of spaced out for.
No, you're fine. I just clicked it and didn't say it. So yeah, so B, right? Murder can be established, right? It was murder, and it was a reckless indifference towards human life. I wanted to check out. You said they made a change on me. The only thing constantly change.
Yeah.
Go
For
ahead,
number
Dina.
12.
Go ahead, Dina. You have a question?
Hey, oh yeah. I wanted to ask two questions. The question about the Supreme Court's appellate jurisdiction. I remember seeing a question where it said the appellate jurisdiction also considers what could be falling under federal law. So, like, even if the state court didn't decide on federal law, but it kind of considered it, it will the writ of certiorari will be more likely to be accepted. I don't know if
Yeah,
my
I
understanding
understand.
is correct.
I understand what you're saying. Like, if it was intertwined with the federal issue or somehow involved a federal issue, the Supreme Court would have discretion to review it because you know, it wasn't wholly on state law because there was some federal considerations. But this question was just asking like, it was more clear. It was like they literally based it entirely on federal law. So the question that you're probably thinking of is something that makes it possible to get into federal court if it didn't really seem like it could. This one was like it could definitely get into federal court. They actually based their decision entirely on federal law.
Okay. It's just like because when you were explaining it, I remembered that question, so I just wanted to make sure.
Yeah, for
Um,
sure.
and then the second thing is, when you were talking about fixtures and whether like if you shake the house, it will move, isn't part of the fixture test is intent, like whether the owner intended for the fixture to remain or as part of the whole house, or
Yeah, I mean the shaking the house thing is just like
okay,
it.
okay, okay.
Yeah, yeah. That there's a more legal analysis than that. I'm just trying to like, there's some
No, because
element.
that's
Yeah,
how I used to think about it. It's like, okay, if you have to take a screwdriver and kind of pull it out, then okay, that's a fixture. But I remember I came across a question where it's like, if the owner intended for it to be part of the like overall house, like just placing a table in a way that is kind of like custom made for it to fit this specific like narrow corner of the house, then that would be considered a fixture because the owner intended for it to be there. I just don't know if that also like will carry through to other questions.
yeah, that's true. I mean, it's a
Okay.
fact-specific analysis, right? Like it has to be really clear that this thing is intended to be affixed to the
Okay.
house. Where like,
Okay.
what shakes the wall, like yeah, if it's drilled in, I mean that's definitely a good sign that it's a fixture. But yeah, there are some other scenarios where you can imagine something being a fixture because like you said, it's part of the house, right? It's like
Okay.
a really special shape that goes. No, that's a good question, and a good thought. Okay, and then you said number 12. Let's see what we got here. So, all right, it's still a property question, but okay. 23 years ago, a woman who owned a tract of land in fee simple absolute deeded to her son and his heirs so long as the premises are used for residential purposes. So that there is a fee simple determinable. It's going to have an automatic right of reversion if it's not used for those purposes. And it is a the durational language, right? That's how you know it's a fee simple determinable, so long as. A one-story building located on the land was used by the son as his home for the next 11 years. Okay. 12 years ago, the son conveyed the land to the friend who immediately began to use it for commercial purposes and continued to do so until his father's death 4 years ago. Okay, that's problematic though, because it had a fee simple determinable condition. So it should probably have gone back um, to the woman, right? To the land to the son and back to the woman. Okay. Um, the friend died intestate, and the land passed to the sole heir who went into immediate possession and at all times thereafter has used the land for commercial purposes. The period of time to acquire title by adverse possession in the jurisdiction is 10 years. There's no other applicable statute. Ooh, this is not what I thought they were going to ask here. I think at first I would say it's going to go back to the woman, but the problem is that the uh, a one-story building located on the land was used by his son as a home for the next 11 years. Okay. 12 years ago, right? We have the conveyance to the friend. So that would automatically revert back to the woman. But over those 12 years, it seems like she adversely possessed the land because she went into immediate possession and thereafter has used the land for commercial purposes. It was definitely open, continuous, exclusive, adverse, notorious, hostile, statutory period. It seems like they probably took it back in adverse possession claim. So the heir, because she has a fee simple absolute in the land. I like that answer. The heir, because she has a fee simple determinable in the land. The woman, because her cause of action against the heir did not begin until the heir inherited the land from the friend. The woman, because once the friend began to use the land for commercial purposes, the friend's interest became uninheritable. What did you guys think for this answer, for the people who did this question?
I put D.
The woman, because once the friend began to use the land for commercial purposes, the friend's interest became uninheritable. And who else did this question? Did you check the answer?
No.
Oh, okay. Go ahead, Dina. Go ahead.
No, I just said like I want to say I did this question.
Oh, you did this question. What answer did you
Yeah,
pick?
I think I put A.
I'm leaning A too because of the adverse possession claim. Like,
Yeah, so it reverts back already, but then there was adverse possession on the land.
yeah, well, it's anyone else do this question? All right, let's see. What is it, 12? Yeah, 12's A. Okay, it makes sense. I mean, tough question. I don't know why they switched this question now. I guess they want to make this test even harder. But that one was tough to me because I was originally thinking, all right, woman is going to prevail because it was a fee simple determinable, and once that it was conveyed to the friend for commercial purposes, boom, it went back to the woman. But the problem is this dude for 12 years, for 4 years, he continued to do it for commercial purposes. Then it passed to the heir. The heir went to immediate possession. That's called tacking. So it tacked right on. And then it was clearly open, continuous, exclusive, adverse, notorious. And the statutory period was 10 years. Good thing they told us this, right? Like I wasn't even thinking adverse possession until I was like, oh, wait a minute. It was supposed to have reverted back. It did revert back. Like it's an automatic reversion. It's not a right of reentry. That's a fee simple subject to conditions subsequent, where there's a right of reentry you have to exercise. This is a fee simple determinable, where there's durational language, and durational language will automatically revert back to the grantor. So here, the so long as language used for residential purposes, 12 years ago, it's used for commercial purposes. It reverted back to woman. Woman, it was her property, but then these people tacked on to each other and adversely possessed it for 12 years, which was 2 years more than the statutory period. They own the land in fee simple now. That's a successful squat. Like I said, I had I forget when I said this, but I was like, the questions on the bar exam are not so common in real life. Like this is a pretty ridiculous. Like the woman was like, "What are you doing? Like what are you doing? It's for residential purposes only. You're clearly using it for commercial purposes." She was literally living in oblivion. And this happened on this question. But yeah, I think that's the best answer to that question. Okay. Anyone else have any questions about that question or any of the questions that we did today? Cool. I mean, for y'all who have, you guys all have access to Birdie, I highly encourage you to use it. The concepts questions are good for, um, fundamentals, and then it's broken down by subject. Then you can do the mix sets. And then, like I said, Tuesday and Thursday, I'm giving my classes, and you're welcome to come to those sessions, the proctored exams for the morning and afternoon session. And then on exam mode, where like the explanation won't come up right away until Friday, I'll turn off exam mode. And then you'll know which ones you got right and wrong, but you won't know what the explanation is until we go over it again on Sunday. But appreciate everyone for hanging out with me today. I'm going to stop this